Steamship Owners Mutual Insurance Association Limited and the Kingdom of Spain and French State Cartel.
Before you continue, Mr. Hancock, I'll just mention 2 points. First, on Friday, we will sit early at 10 o'clock, but we will finish at 10 to 4, which means you have the same amount of time, but it's moved slightly forward. Second, you may or may not have noticed that a number of judgments were made public recently relating to Sheikh Al Maktoum. One of them deals with the issue of what qualifies as a counterclaim in circumstances which are quite closely related to the State Immunity Act. You may want to look at that case. It may or may not turn out to be relevant. I think rather than take up time during the hearing, the best way to deal with that is that if you want to say anything about it, you should put in short written submissions, which you must do by 7 days after the close of appeal, so by Friday of next week. It also says something about what is needed to prove a rule in customary international law. So if you think any of that is relevant for our purposes, that's the way to deal with it.
Thank you. My Lord, do you happen to have a date for it being handed down so that my
I have a reference, which is 2021 EWHC 660 family, and permission to appeal was refused, but the Court of Appeal judgment doesn't really deal with those issues. That's 2021 EWCA Civil 890. They were heard earlier in the year, but they were heard in private and only made public in the last week or two. Yes.
Obliged, my Lord. I have, I think, 2 other points that I need to make, which I will make as briefly as possible in relation to State immunity. The first is in relation to the Contracts Rights of Third Parties Act 1999. That isn't something which Mr. Young dealt with in his oral submissions at any length, but it is dealt with in the State's reply skeleton. And since there isn't anything in our skeleton, because of the fact it was raised in the reply skeleton, I thought I should deal with it very briefly orally. As your Lordships know, then the 1999 Act confers benefits on third parties in certain circumstances where those benefits arise under a contract. 2 cases are cited, the case of Nishin against Cleves and the case of Fortress Value, but neither of those cases take matters any further because they don't consider the discrete question that Mr. Justice Henshaw had to consider. But the Act itself is, I would submit, worth looking at, and your Lordships will find that at bundle A1 of the authorities at tab 4. And if your Lordships go firstly to section 1, subsection 4 of the Act, that states that the section, which is the section which confers rights on the third party to enforce a contractual term, does not confer a right on a third party to enforce a term of the contract otherwise than subject to and in accordance with any other relevant terms of the contract. So that section, or that subsection, reflects the concept of conditional benefit. And indeed, in the explanatory notes to the Act, which are set out in the judgment of Mr. Justice Coleman in the Nishin and Cleves case, he sets out those explanatory notes and explains that the subsection was intended to reflect the doctrine of conditional benefit as derived from the J. Bowler. Then if one moves on in the Act to section 8, that's the section that deals with arbitration provisions. And the reason why Section 18 was thought to be necessary was because of the fact that Section 1.4 alone would not make a third party a party to the arbitration agreement for the purposes of the Arbitration Act, because there's no equivalent provision to that which exists in Section 82.2 of the 1996 Act. And so Section 8 was inserted into the Act. And your Lordship will see that it states that where a right under Section 1 to enforce a term, the substantive term is subject to a term providing the submission of disputes to arbitration, the arbitration agreement, and the arbitration agreement is an agreement in writing for the purposes of Part 1 of the 1996 Act. The third party should be treated for the purposes of that Act as a party to the arbitration agreement as regards disputes between himself and the promissor relating to the enforcement of the substantive term by the third party. And then it goes on in subsection 2 to deal with the situation where the third party exercises the right, and in those circumstances, again, the third party is to be treated as a party to the arbitration agreement. So the relevant point I would submit is that it makes clear, this Act, that in the circumstances in which it applies, then a claim to enforce the substantive term of the contract renders the third party seeking to enforce that substantive term a party to the arbitration agreement as regards disputes between himself and the promissor relating to the enforcement of the substantive term by the third party. So therefore the question would be, just applying that to the facts of this case, if there is a claim by the third party in the States to enforce the substantive rights, here their claims in Spain, disputes in relation to those claims are then to be arbitrated. If one asks, are the club's claims against the States arising out of the pursuit of the claims in Spain disputes which relate to the enforcement of that substantive term, then the answer to that question I would submit is quite clearly yes. And that analysis is in line with the analysis to which I referred your Lordship yesterday of Mr. Justice Moore-Pick in the Through Transport No. 2 case and the courts in the Prestige last time round, namely that where actually a party makes a claim and that claim is disputed, then either party can then refer that dispute to arbitration, and the other party is obliged to abide by the reference to arbitration.
So what's your submission about this? Because the claims by the states in Spain are not made under the 1999 Act,
Yeah.
but you say that the 1999 Act illustrates how the conditional benefit analysis derived from the cases on which it's based should operate. Is that how it works?
Yes, and I refer to it because of the fact that the states relied upon the 1999 Act. We would say that what the 1999 Act shows is exactly what your Lordship says. It was itself referable to the principle of conditional benefit, and it therefore illustrates how that principle of conditional benefit applies to a case such as this.
Yes.
That's the first point, my Lord. The second point is an entirely separate point, and that is that Spain has raised a further additional argument on appeal to that which it raised below, or indeed in 2013 to 2015, and that is that the obligation to arbitrate pursuant to the principles of conditional benefit violates the state's rights under Article 6 of the European Convention on Human Rights. I would say several things about this point. The first is that was a point that was going to be raised, that should have been raised back in 2013 or 2015, because of the fact that it's an argument that effectively goes to the validity of the obligation to arbitrate, which was the very question that the courts had to determine in 2013 and 2015, and accordingly, in accordance with general principles of the use of process and issue stoppable, then the states should not be allowed to raise the point now. The second point is that it is, in our submission, a bad point anyway. It is accepted by the states that parties are free to refer disputes to arbitration, and that the simple fact that disputes refer to arbitration does not involve a violation of the European Convention. That is clear in particular from the Stretford football case. That's to be found at Authorities Bundle 3, tab 28. I won't take your lordships to it now, but it sets out a clear exposition of the principles which are set out in the European cases on the point. In short, what the Court of Appeal said in that case was that arbitration under the 1996 Act did provide for a fair and impartial hearing. They dealt with that in paragraphs 33 to 40 of the judgment. That is a requirement which may not be waivable, but since arbitration complied with Article 6, there was no question of the waiver of that right under Article 6. What there might then be a waiver of where arbitration was an issue was clearly the right to a public hearing before a court, but that actually is a right which clearly is waivable. A party may consent to arbitration and thereby waive the right to a public hearing. In order that that be the case, the consent to arbitration has to be consensual. There has to be an express or tacit waiver, and the waiver may be tacit, as long as the consent is voluntary and not compulsory. And by the word compulsory, then the Strasbourg courts mean required by law. And your lordships will see that from paragraphs 41 to 53, and particularly 45 and 48 of the authority. So the question here would be whether Spain and France had voluntarily consented to arbitration. And I would just submit that the answer to that question is clearly yes. A similar argument was raised in the Court of Appeal last time round in relation to Section 9 of the State Immunity Act, where it was argued that Section 9 of the State Immunity Act required true consent to arbitration. Lord Justice Morbitt said in paragraphs 65 to 66 of that judgment that the questions for decision are whether the appellants consented to arbitration, and if so, whether it is sufficient to satisfy Section 9(1) of the State Immunity Act that a state has consented to arbitrate in accordance with terms recorded in writing. And at 66, he said, for as long as the appellants continue to maintain their claims, I do not think that the states can be heard to say that they have not consented to arbitration, or that the consent necessary for a submission to the jurisdiction of the English courts as the supervisory jurisdiction over the arbitration is lacking. That's paragraph 66 of the Court of Appeal's judgment. So we would submit that clearly Court of Appeal considered the question of whether there was sufficient consent to arbitrate and concluded that there was such consent. And I might also say that tacit consent is enough. We see that from a case in the European Court in which there was a right to insist on a public hearing. The party in question, I think it was Denmark, I can't now remember the name of the case, it is in the bundles. The party in question did not insist on the public hearing, and the mere fact that they did not insist on the public So here actually, Spain and France's conduct in making their claim goes well beyond, in my submission, tacit consent by failing to raise the question.
It's a bit odd to think that you consent to arbitration by bringing a claim in Spain. I can see that you could come under an English law obligation in equity as a result of doing that, and that's the analysis adopted in the cases. But if you're looking for consent, it seems odd to think that you would consent to something by conduct which places you in breach of that obligation.
Well, no. The question is whether or not your conduct actually, whether or not you have the right to insist that your claim is not determined in arbitration because of the provisions of Article 6, and the doctrine of conditional benefit means that by virtue of bringing your claim in Spain, you thereby accept the obligation to bring your claim in arbitration. That in turn is an acceptance of the fact that your claim will not be dealt with in a public hearing. And so it is true, as my lord puts it, that in a sense the making of the claim would indicate that you are not consenting to arbitrate. But the whole point of the doctrine of conditional benefits is that is not something that you are permitted to do, because you have actually, if you're going to take the benefit of the contract, to accept the condition upon that benefit, namely that you must arbitrate it. You have a choice as to whether you bring the claim at all, but if you do bring the claim, then you consent to arbitrate that claim. And the fact that the obligation is imposed on you in equity doesn't mean that you are being compelled to bring the claim. I'll come back to this in an attempted answer to my Lord Justice Phillips's question in relation to 3.1b when we come on to the Brussels regulation. Because obviously the obligation that arises in this case only arises because you are making a claim. Your choice as to whether you make the claim, but when you make the claim, you accept the obligation to make that claim in a particular forum, because it is a condition of the right to make that claim, that you make the claim in that forum. That's the whole basis of the doctrine of conditional.
Yes. All right.
But it works at both ends, doesn't it? Because in the sense that the obligation of the club under the contract is subject to all the terms of the contract, including the arbitration.
Sorry, the obligation of the owner and therefore the obligation of the states.
No, the obligation of the club.
Yes. I'm not sure I'm following your lordship's question.
Well,
It's
it seems to me that when they claim against you,
yes,
they're saying you owe an obligation under the contract, but that obligation is surrounded by an arbitration clause.
yes,
Pointing in your favour, I'm not.
yeah, no. It's a mutual obligation. The obligation to arbitrate.
Yes.
If you're going to make a claim on the substantive term, then you're obliged to accept the obligation which is imposed on.
It's not just a mutual obligation; it's a right which the club has. A right
It's
only to be sued in arbitration. Only to be
It is.
pursued in arbitration.
It's also actually an obligation on the club. So
Yes.
if the position is that the states have turned around and said, we insist that you arbitrate our claims, the club would have had to accept it.
Well, you could say, I suppose, that the obligation of the club in the event of dispute is to pay what arbitrators say they should pay and not to pay what somebody else says they should pay.
They said they could waive it.
They can waive it, of course.
Yes. Yes. In a sense, they all come around to the same thing, which is that you've got the forum selection clause within the contract, the arbitration clause, and the parties have agreed, as your lordship say, that their rights are to be determined in a particular way by a particular tribunal. And the particular tribunal in this instance is the arbitration tribunal.
Well, when you take the benefit of the contract by claiming under it, you can say, well, you have to accept corresponding. You also say, well, you take the contract as a whole.
Yes.
It doesn't matter how you put it. It's the same.
No, your lordship is absolutely right. The fact of the matter is that what it amounts to is saying you can't take one part of the contract without accepting the totality of the contract. I mean, again, going back to that well-worn phrase, you can't take the plums without the duff. You've got to take the whole pudding.
And that may be analysed by way of implied consent.
Yes. My lord, I just check briefly. I think those are all the points I needed to make.
Could I ask, let's go back to section 9 in
Yes.
the context of the arbitration. Understand what you say. What you have to say is they've agreed in writing to submit a dispute to arbitration. In proceedings which relate to the arbitration. Which arbitration do you say, in the context of the arbitration claim, which arbitration does it relate to?
The new arbitration.
Why?
Because of the fact that the application is to appoint an arbitrator in that new arbitration. And the proceedings relate to that new arbitration because they are proceedings to appoint an arbitrator in that new arbitration.
Well, I understand that side of it, but why is that an arbitration to which they've agreed in writing to submit a dispute?
Because of the fact, as I was indicating yesterday, that in making the claim in Spain, then they came under an obligation to arbitrate disputes relating to that claim. One of those disputes is the dispute as to whether or not in continuing in Spain they acted in breach of that obligation. As I said to your lordship yesterday, then a failure to abide by the terms of an arbitration agreement is itself an arbitrable dispute.
I understand that, but what my concern is that, as I read 9.1, it seems to anticipate that it's talking about one arbitration, the arbitration. Does it refer to multiple arbitration?
It can do, yes, I mean, because, take a concrete example, let's assume you have an ongoing contract between two parties. Let's assume you've got a charter party. And there is a dispute which arises in relation to the payment of hire.
Then there's later a subsequent
period
issue.
A
I
and
understand
period
that.
B. And your lordship has one.
Yes.
That may simply be successive disputes, each of which gives rise to an obligation to arbitrate.
But you don't say that the Section 18 application relates to the SHAF arbitration.
No, we say the Section 18 application relates to a commercial transaction under 3.1a.
No, for Section 9 purposes.
For the Section 9 purposes, we don't say that it relates to the SHAF arbitration. That's why, in fact, if you look at the state skeleton, they draw a distinction between the Section 18 application and the other two actions on the basis that the other two actions relate back to the SHAF arbitration, whereas the Section 18 application relates to the new arbitration. We would agree with that.
Mr. Young's point on that is he says it was all very well to infer an 82, Section 82 participation in the SHAF arbitration because that corresponds to that correspondence to the claim. But now you're talking about a new arbitration which doesn't correspond to the claim at all.
Yes.
How do you bring it within Section 82?
Well, I would say Section 82.2 is unnecessary in relation to that anyway, because the fundamental question, if you go back to the J. Bowler and the conditional benefit cases, they have nothing to do with Section 82.2. Section 82.2 came in the Prestige because of the dispute in relation to Section 9 of the arbitration agreement in writing. And the Court of Appeal held, well, you were a party for the purposes of the Arbitration Act in relation to the question whether there was an agreement in writing within the arbitration agreement, because you were claiming through a party to the arbitration agreement. The J. Bowler question is a separate and logically anterior question. That's to say, are you bound by the arbitration agreement? And we would say that the states are just as much bound by the arbitration agreement in relation to the club's claims or the state's conduct in acting in breach of their obligations to arbitrate, as the states were bound by the obligation to arbitrate those same claims. Indeed, as both of the first instance judges have held, it would be an extremely odd conclusion to reach to say that there was an obligation to arbitrate the claims, but no obligation at all to arbitrate the claims for breach of the obligation to arbitrate the claims. It would be a pretty toothless position if one could say that, yes, we have to arbitrate our claims, but if we don't, so what? If we don't actually then have to arbitrate your claims for our breach of our obligations, admittedly arbitrable obligations.
Well, you're in the same position as you are with the other claims, which is you bring proceeding.
Well, you could do, but the...
There's no difficulty about that, as you've demonstrated.
But again, except the fact that the later proceedings relate to the awards and the judgments, the Section 18 proceedings relate to the continued breach of the arbitration agreement. And so, just as way back in 2013, the bringing of the claim was a breach of the obligation to arbitrate, albeit a breach which the states at that stage only claimed declaratory relief in relation to, because of course at that stage the club only claimed declaratory relief in relation to, because at that stage the club hadn't suffered any monetary loss. The club only suffered monetary loss thereafter by reason of the state's continued pursuit of the claims, generating the need to expend costs in Spain and generating the Spanish judgment, which imposed liability on the club, which would not have been imposed had the states adhered their obligation to arbitrate those claims in this country.
I suppose you also say that once you become a party under Section 82.2, there's nothing to say the states have stopped being a party.
No, that's true too. Sorry, that's also a quotation from King Lear, but not a very helpful one.
Never.
Well, I'm conscious that I was going to be 10 minutes, and I've been a bit more than 10 minutes, but unless I can be of any further assistance to your lordships, which is always to assume that I've been of any assistance at all thus far, then those were my submissions.
Yes. All right. Thank you very much, Mr. Hancock. Mr. Young.
May it please your lordship, if we're reverting to King Lear, I'm presumably a foolish, fond old man, but I'm going to do my best to be a quick one. I have handed up to your lordships 2 cases that were referred to yesterday. The judgment of my Lord Justice Popplewell, as he then wasn't, in the Seamaster, and it's there for your lordship's assistance. I also referred to the Aramis, which is the judgment of the Court of Appeal in 1989. Ironically, it was the one reported immediately before the Padre Island. I have, you may think at page 224, I've given you my copy, which has been highlighted by me rather inelegantly. That was because I know that when we provide judgments to the court, we should have it highlighted. And the passage there I'm sure it's a familiar passage to your lordships about the implication of contracts. You'll remember that the Aramis was a case about whether one could imply a Branton-Liverpool contract in the circumstances of that case. And the Court of Appeal asked the questions which are in the middle paragraph, or the middle two paragraphs, and they came to the conclusion no. And Lord Justice Bingham pointed out that if the answer to the two questions in the top paragraph, one, whether the conduct of the bill of lading holder in presenting the bill of lading to the ship's agent would be reasonably understood by the agents or the ship owner as an offer to enter into a contract on the bill of lading terms, and two, whether the conduct of the ship's agent in accepting the bill or the conduct of the master in agreeing to give delivery or in giving delivery would be reasonably understood by the bill of lading holder as an acceptance of his offer, i.e. You find that is there an offer and is there an acceptance? And Lord Justice Bingham says, I don't think it is enough for the party seeking the implication of a contract to obtain it might as an answer to these questions, for it would, in my view, be contrary to principle to countenance the implication of a contract from conduct if the conduct relied upon is no more consistent with the intention to contract than with the intention not to contract. Now, this may have some bearing on my learned friend's case about the implication of a contract and implication of consent. But anyway, I provided your lordship with the judgment in that case, because having referred to it, it would be quite wrong for me not to provide it to you. Now, my lord, it has to be said that most of the points that I was going to mention in by way of reply, which I put in my notebook, were points which your lordships, by one way or another, put to my learned friend. Now, I make no assumption as to whether you thought they were good points or bad points in putting them, but what they were points of which you were cognizant. Therefore, there is no need for me to raise them by way of reply, because they are already in your mind. If they're good points, then they're good points. And if they're bad points, my saying, repeating it in a reply, doesn't make them any better. Indeed, there are those who may think it might make them worse. But a lot of the points you made to my learned friend, I'm going to treat as saying, may I attach myself to the coattails. But as you're obviously aware of them, that's all that need matter. So with that introduction, I have 5 points. May I just give you the titles of those 5 points, just so we don't lose sight. One is decide the section 9, the SIA point. 2 is the declared restatement of obligation point. Those will be in inverted commas. 3 is the relating Svenska NML section 3 point, rather broadly adopted. 4 is the Human Rights Act point, which actually has two aspects. And 5 is counterclaims, in inverted commas, and I'm grateful to my lord for drawing our attention to the Al Maktoum case. I'm afraid that the family reports are not something that I necessarily look at when I first get into chambers, but I'm grateful.
They can be very instructive, Mr. Young.
I have absolutely no doubt, and indeed, when one thinks about it, cases like Tode and Tode on issue estoppel arise out of family cases. However, you're right; they are very instructive, but I'm afraid it's not my normal diet. Now, decide the Section 9 point. Now, when my learned friend put in his skeleton at paragraph 67, the question therefore requires the court to determine the jurisdiction of the arbitrator and to do so on a final basis on the balance of probabilities. The parties agree that given the judge decided this question finally, and since it is likely to arise on a future Section 67 challenge, the court should determine this question finally, irrespective of whether another ground of immunity applies. That's what he actually said at 67. He's now backed away from that. And in my respectful submission, your lordships should decide it now. Because, really, for two reasons. One, the club is asserting at least in the arbitration of which I am cognizant, before Sir Peter Gross, that Mr. Justice Henshaw's decision creates a binding issue estoppel, so that there is no available dispute about the learned arbitrator's jurisdiction to determine the club's damages claim.
Would that still be the case if we were to say we're not going to decide the point and we don't treat it as either right or wrong, express no?
Well, the way it's put by my learned friend is that it is a decision of the court which is sufficient to create an issue estoppel. And if you just say you're not going to decide the point, then it remains. It's either Mr. Justice Henshaw was right or he was wrong. And
I don't want to hesitate to rise, but actually my learned friend is wrong in saying that we contend that there's an issue estoppel in the Spanish arbitration, because we accept that there are alternative ratios in Mr. Justice Henshaw's decision. In the French arbitration, we do actually say that there's a binding issue estoppel because Mr. Justice Foxton only found himself on Section 9.
well, I'm certainly having partaken so far in the Spanish arbitration. That's perhaps not quite my understanding, and it may or may not be Sir Peter's understanding. But wearing my my French hat,
Yes, you'd say on behalf of Ms. Stillnot, you'd say the point you're making
I would say, voilà, ça se comprend.
applies to Mr. Justice Foxton.
Exactly. So you really should decide it. And in my respectful submission, there is a second, a rather more insidious procedural point that my learned friend says, well, Spain or France, I suppose, can raise the point later in a Section 67 challenge. The problem with that is that completely undoes the point, because in order to raise it by way of a Section 67 challenge, the relevant state, whichever it is, has got to submit to the jurisdiction of the court, and voila, it's already done it and lost the immunity. As indeed was shown by the Court of Appeal in Prestige in Step in the Proceedings case. So, in my respectful submission, it's far preferable not to leave it to Section 67, which will then become self-defeating, but to decide it one way or another now. It will save everybody a lot of time and angst. And it is a pure point of law, or a pure point of pure law. And my learned friend, as I say, he's in his skeleton, he said, you should decide it. He's now backing away from it. I'm going to hold his feet to the fire and say he should stick by what he accepted then. Obviously, I'm not saying he can't depart from what he says in his skeleton. Of course, he can, but you shouldn't resist the urge to decide the point one way or another. That's the Section 9 point. Now, one of the points that was actually raised just now, I think by my Lord Justice Phillips, I'm already going against what I said at the beginning, but if I may just adopt that, which arbitration are you talking about to which the states have consented? And the answer is the dispute which was about the right of the states. My learned friend says, well, his case is just the other side of the coin. No, that isn't right. What he said was the other side of the coin and if I can probably put this, I think, most adequately in my learned friend's own words, if you look at the supplementary appeal bundle, which has got the materials relating to the hearing before Mr. Schaff and the award.
I think we got two. You want the new one, do you? That came in the other day.
Volume 2, yes. I mean, I must confess that the other side of the coin argument, the way my learned friend raised it, did strike me as out of accord with what he put before Mr. Schaff. If you look at this is his skeleton before Mr. Schaff. Page 287, sorry. Page 15 internally, SB 287. Paragraph 35. He there quite correctly identifies what is the other side of the coin. The club's claims for negative declaratory relief, as explained below, concern the existence and scope of its liability to the Spanish state in respect of the contract, if any, including the club's entitlement to rely on contractual defences. These disputes are simply the other side of the coin of the Spanish claims for compensation. As to that, of course, he's right, and that's what the Court of Appeal held. What he's now saying is that the development, which he is now seeking to inject, is the other side of the coin, and that isn't. So I rely upon his own formulation of what is the other side of the coin to undermine his argument that what is now being sought is a development. And if one thinks about it in the context of Section 9...
But sorry, can't they both be other sides of the coin?
Coins only have one side,
or is
two
it
sides.
just an inept metaphor?
It's an inept metaphor. It may be an inept metaphor, but it's just...
We're not going to decide the case on the basis of whether...
nor indeed the toss of a coin. No, I would accept that one. But it's metaphors... Metaphors can be useful up to a point, and they can generate inexactness of analysis. And I'm going to say quite a lot of what my learned friend's case involves is an imprecision of analysis when it really comes to the crunch. And the point that was made by my Lord Justice Phillips this morning to my learned friend, whether he thought it was good or bad, is which arbitration did the states consent to? The arbitration before Mr. Schaff? The answer to that is obviously yes, because that's what's been held by the Court of Appeal, and the states don't say otherwise. But if one asks oneself, it was done on the basis that there was a dispute which had arisen, and that dispute was then referred to arbitration. Now, one asks oneself, what dispute is now being sought to debate? It's a dispute which hadn't even arisen in 2019, and indeed my learned friend himself said, well, back in 2013, we hadn't suffered any loss. In fact, I haven't suffered a loss.
So what? You can agree to refer to future disputes.
Oh, you are absolutely right. You can. But the question is, as between contracting parties, you can. But here, we don't have contracting parties. We have got a conditional benefit claiming non-party. And you have got to infer an arbitration agreement in relation to a dispute. Now, it's in relation to a dispute which had not then arisen. And indeed, if the case is, well, you can agree to refer future disputes, and the appointment of Mr. Schaff was done in very wide terms, then Mr. Schaff is still the tribunal.
We don't need to infer, do we? Because once you've made the claim, you are party to the arbitration agreement under section 82.
In relation to the dispute which was referred. You see, this is why it's...
Why do you say that?
Well, because that is the basis upon which the Court of Appeal held that we were parties to the arbitration agreement for the purposes of under section 82.2.
But section 82.2 is quite clear that a party claiming under or through a party to the agreement is included amongst the parties to the arbitration.
Well, yes, but there was, and the arbitration agreement was solely in relation to the conditional benefit, because that's all it could have been.
Why?
Well, that's my submission. Your Lordship's going to have to answer that question.
But the conditional benefit, the whole part of that is that in order to take the benefit that you're seeking, the condition is you accept, as per Article 82, Section 82.2, that you become a party to the arbitration. And it's in relation to the enforcement of my right, to which the response is you don't have a right because there is a pay-to-be-paid clause and the club has no liability. End of case. Absolutely end of case. I just don't see where you get that from the section.
Well, as I say, the problem in this case is that we aren't... if we were just talking about two contracting parties, I would absolutely agree. And what my learned friend said about multiple arbitrations between contracting parties.
Well, if it's just two contracting parties, we wouldn't be looking at 82.2.
I quite agree. But you have then to say, what have the states agreed to arbitrate? That's the question you have to ask.
Well, no, we have the arbitration clause. That's what they're parties to. So we look at the arbitration clause to see what they've agreed to arbitrate.
You look at the submission to arbitration to see what they have agreed to arbitrate. That's what my learned friend relied upon the bombastic for that. He's got other problems emerging from that. But for the moment, all I'm doing...
You say the making of a claim does include an agreement to arbitrate. Forgive me. A category of dispute which is related to the claim, to put it neutrally at the moment.
Yeah, fair enough. I would have
it does not, you say, constitute an agreement to arbitrate any claim which happens to fall within the arbitration clause,
exactly,
which may be wholly unrelated to the claim which gives rise to the conditional benefit analysis.
Exactly. And that, when my learned friend referred to the 1999 Contract Rights of Third Parties Act, he's in A1, tab 4. He alluded to section 8.2, but didn't actually finish the reading. And it ends up, the third party shall, if he exercises the right, be treated for the purposes of that act as a party to the arbitration agreement in relation to the matter in respect of which the right is exercised. It's a limited reference. That's under the Act, and I say the analogy is pretty exact in our case. But you have to ask yourself, the question is always in the Section 9 issue, is did the states consent to arbitrate claims which were not mentioned for another 6 years before Mr. Schaff? It's impossible to say that they did, because if they didn't even know that the disputes existed, and indeed, we're not talking about an arbitration before Mr. Schaff at all now for the purposes of Section 9, the analysis simply lacks cohesion.
But why does it?
Well,
Because you continued the claim, which continues to be a breach of the arbitration.
Well, and it may be a breach of the arbitration agreement, although that is, if I may respectfully say so, putting it rather starkly. But one asks oneself, what had the states consented to arbitrate? And it was the dispute before Mr. Schaff.
You're continuing to bring the claims, which continues to come with the
Yes.
additional benefit.
That may be. That may be, but it was not a dispute about the club's entitlement to recover damages. They never made that claim. They never indicated that there was a dispute about that at all.
But if they had at the time, suppose the situation had been that at the time they had been participating in the proceedings and had incurred some cost.
Proceedings in Spain.
It may be they incurred some cost anyway, but however that may be, suppose they had, and then they brought the damages claim straight away in front of Mr. Schaff.
If they brought a damages claim straight away, that would then have been the subject.
That would have been the subject matter of the agreement to arbitrate.
That would have been the subject of the appeal. And then there would have been a question as to whether that was itself one of the disputes which had been submitted to arbitration before Mr. Schaff.
Again, my lord, I do hesitate to rise
Sorry.
and interrupt my learned friend, but he's indicated that we never indicated that we were going to claim. We did indicate repeatedly that we were going to claim on the basis of their continued proceeding within the state. We sent letters indicating that was what we were going to do at the time.
Well, in which case, then, they were indicating they were going to, but they didn't take it. The point is that, and it is the point that my Lord Justice Phillips identified, is that there are two arbitrations that are analytically material here. The arbitration before Mr. Schaff and the arbitration before Dame Elizabeth. Sorry? Gloucester. Yes, thank you. Dame Elizabeth, I was about to call her Gross, or Sir Peter Gross. They're two different arbitrations. That necessarily must follow from the club's argument, because otherwise Mr. Schaff is the proper tribunal, and therefore the appointment of Sir Peter or Dame Elizabeth must be completely vacuous.
But why?
You know, I thought the Section 9 point was going to be relatively short.
After the decision in the original arbitration declaring that you must arbitrate this claim,
And we are bound by the clause.
and you're bound by the clause, you ignore that and you continue the claims. Why would they not have been entitled to go back to start a fresh arbitration, to enforce the arbitration clause, or seeking further declarations that what you were now doing was also a breach of the arbitration?
They would have been entitled, perhaps, to try. But the point is, the question is still whether the agreement which you have got to infer, I mean, you've got to infer an agreement by the states to the arbitration now before Sir Peter or Dame Elizabeth.
Well, never mind what the arbitration, never mind that claim. But what about if they had brought a further claim saying you're still pursuing this claim
Before Mr. Schaff?
well, or no, a fresh arbitration before whomsoever?
So they've then got to identify the consent and the agreement that Spain has given to that.
Yes,
Because by definition,
you're still pursuing the claim.
Then you apply the criterion of the Aramis, and you would have to say that any action, any conduct by Spain was entirely ambiguous, ambivalent, as I think my Lord Justice Mayles put it. It's difficult to see that one's submitting to arbitration by proceeding with a claim in Spain.
So you would, in those circumstances, have consented, as it's been held, to an arbitration to decide whether proceeding in Spain was a breach of...
Hang on, you said I would have consented.
This court has held in the Prestige No. 2 that you did consent for
Yes.
Section 9 purposes to arbitration of the dispute about whether you were bound to arbitrate the claims in Spain.
Well, the dispute that was before Mr. Schaff.
Which was
Yes.
whether you were bound to arbitrate the claims in Spain.
Yes, I'm just trying to make sure we keep focus on what it is that Spain is deemed or impliedly
Yes,
consent.
and we need to look at the substance of it, which is they're deemed to have consented to arbitrate whether the proceedings in Spain were a breach of the obligations.
No. Whether they were obliged, whether we were could enforce our right otherwise than in arbitration.
Yes. So your point is you had consented to determination of the question to that question, but not to the question as to whether you were in breach.
Not to the question as to whether we could be liable in damages.
Question whether you were bound to arbitrate those proceedings, but not the question whether by doing so you were in breach of your obligations.
No. The question of whether the club had an actionable claim in damages.
How's that different from whether you're in
very different.
breach of your obligations?
Well, because one is referable to the state's right, and the other is referable to a liability in damages. As I put it at the beginning, that the conditional benefit then becomes an unconditional liability. So the point is, you've got to ask yourself the question, did the states, by their conduct, impliedly agree to arbitrate the club's monetary claims? And you apply the test, the criterion of the Aramis, and the best you can get is it might. And that is simply not enough in law for the implication of an agreement. Or indeed, I would respectfully submit in the context of the Human Rights Act, indeed, in due course, not enough to imply consent. So, as I say, I thought that Section 9 was going to be relatively short.
Well, I know you've had a lot of questions to deal
Yes.
with, so to some extent it's not your fault, but we've so far taken half an hour on the first of your 5 points.
I know. I was anticipating that I was just going to say, you've got to decide the Section 9 point, and then I was going to leave it. I've been... obviously, it's an important issue, but it is a consistent theme of my submissions that one must and this perhaps raises the point about the metaphor, that one must, at the critical point in your lordship's analysis, be very precise as to what you're actually concluding. It's no good for my learned friend to say, well, there's an obligation to honour an award, or there's an obligation to abide by a judgment. What is the analytical source of the obligation, particularly when one is involving a third party who is not otherwise bound? And what is the precise character and formulation of that obligation? And it is absolutely no good just airily to talk about honouring the award. As I think when Lord Hobhouse used the term, he meant pay the sum as awarded. I think when everyone sees it.
It may be, but when you are flagrantly ignoring the arbitration decision and the decisions of this court and pursuing a claim which, as far as this court is concerned, you should not be pursuing, it cannot be surprising to you that,
you use the word,
that there will be routes which can be availed to have sanctions for
there may be, but
this court won't be slow to
well,
look at those.
Flagrantly, ignoring. Actually, both sides ignored it. Both sides ignored it because the club could have gone to Spain, the courts of Spain, and said, look, we have an award in February 2013. We have a judgment of November 2013. We have a judgment of April 2015. We have got a perfect res judicata or a perfect issue estoppel or any number of defences. It can be used entirely defensively. It's no good saying, if you'll forgive me saying so, my lord, it's no good saying we were ignoring it, so were the club. The club had the perfect opportunity to utilise the award that they'd got. And indeed, when you look at the passage in the transcript before Mr. Schaffer, which I referred you to, but you may not yet have had the opportunity of looking at it, you'll see that it was intended to be used defensively. So,
well, you may think that
both
that's the best form of defence, but you are not dealing with the point, which is the fact that it's the state here which has pursued the claims.
Yeah, yes. It was the use of the word flagrantly that perhaps excited my enthusiasm, my lord. Both sides were carrying on as if the award and the judgments had not been made.
I don't understand that. I really don't understand that.
Well, if you don't understand, well, I've made the point. My learned friend's going on his feet again.
I just wanted to make the point, my lord, that a number of the points that my learned friend has just made as to intervening in Spain and whether or not it would have been possible or feasible to successfully intervene in Spain are in dispute between the parties. And there is expert evidence of Spanish law, which is before the courts and arbitrators dealing with those issues. And what my learned friend has said does not fairly reflect that evidence.
Well, I rather doubt whether this case is going to turn on what the club might or might not have
I think it's
Spain, and it's up to you, Mr. Young. But
No,
as I said yesterday, this is coming out of the state's time.
I'm very anxious to, but at the same time, I must just insist, if I may, on analytical precision. And it's...
All right, well, we will do our best to produce
Yes.
a judgment which contains, at any rate, some analytical precision.
Well, I'm grateful for that. That is helpful. The second point, I hope this can be slightly quicker, the declared restatement of obligation. My learned friend yesterday said in the transcript, which I have got, at it's pages 94 through to 98. I don't know if you've got the mini script version. You don't have it.
Haven't yet been provided with a hard copy.
At page 94, lines 13 to 16, my learned friend said, so here, actually, obviously, the obligation in the award is a restatement of the obligation that already existed, namely to arbitrate the state's claims. And then on page 96, at 13 to 20, he said, what we would say actually that the obligation in the contract, which is then actually restated in the award and in the judgment again, is the obligation to arbitrate the state's claims. And then going over to the bottom of 97, he repeated that the fact that what the award and the judgment did was merely restate the pre-existing obligation. Now that must necessarily mean that no obligation can arise from the award or from the judgment. And this is, as soon as it's nothing other than a declaration of what already exists, then no obligation derives. And therefore, at its fundament, the arbitration, the award claim and the judgment claim are both founded upon a complete misapprehension. And because the only claim that could possibly be advanced on my learned friend's own argument is that based on the pre-existing obligation. And the award and the judgment did not create obligations. They merely said that the previous obligation existed. Now, in a case where there has been a separate, discrete submission to arbitration by the states, it is plainly right that there was an obligation in that regard. I've not hesitated about that. But where my learned friend's case is founded upon the pre-existing agreement, there there is and can be no pertinent or independent obligation arising from the award, otherwise than with respect to the initial deemed agreement to arbitrate. And if no obligation can arise from the award, by definition, as a sustainable cause of action, it's not a cause of action on the award, it's a cause of action on the right which was declared to exist by the award. And thus, I fully accept that that leaves the Section 18 point, but my learned friend's own exposition of what it was that the award and judgment achieved, he has completely undone his case as a matter of substance on the award and judgment claims. And it's vitally important because that is actually the complete answer to this case. Irrespective of issues of immunity, unless he can say that there is a discrete new obligation arising only from the award and only from the judgment, then those two actions are fundamentally flawed. Now, this is going possibly to the serious issue to be tried.
Well, I'm a bit concerned that you might be replying on a point where Mr. Hancock has not yet developed
Well, I'm
his full
replying.
submissions. I know you say that these things need to be decided under the heading of state immunity, but and you've made the point, and you referred us to Zavarco yesterday or whenever it was.
Yes. Day before.
Yes. Whenever. But just thinking about the most efficient use of time.
No, I'm.
If there is more to come from Mr. Hancock, perhaps there isn't. But
my lord, no. It's the fact that it's when my learned friend said it's a restatement of the obligation. I'm afraid I instantly thought then he has completely undone two of the actions. As a matter of pure analysis, there is no sustainable, persisting, sustainable cause of action.
I think we understand.
You've got the point. And it's a fortiori with the judgment, of course, because it's even more difficult to construct any fresh agreement. And I do, because my learned friend said it in his submissions, it was, even though it's not immediately specifically relevant to the immunity case, it is very, very important at the outset that, once again, you hold his feet to the fire on what is actually the cause of action in the judgment and award claims. But it is relevant to immunity because of Section 3.1b, which my learned friend is still persisting in, where he has to have performance. And that's an issue which we have engaged in already, but it's performance of an obligation which was merely a restatement of a prior obligation and not arising out of the award or the judgment. So it is pertinent to that particular head of exception to immunity, although it is much more fundamental. My lord, I turn the third point, and I hope I'm going to go faster now. The relating the Svenska point. The linking factor between my last submission and this is the judgment of Mr. Justice Akins in the Bumbesti, which my learned friend referred to, which is in the C bundle of authorities at tab 16. And my learned friend relied upon this, but in truth, it undoes him. When one looks at page 566, it's tab 16. He considers the authorities in the famous case of Bremer and Drury, where I think famously the Court of Appeal said that the action on the award is really founded upon the agreement to submit the difference of which the award is the result. And where there has been no submission to arbitration by Spain for the reasons identified by my Lord Justice Males, one needs then to go back to the initial agreement if there was one, and that requires you to determine whether there was or was not a relevant agreement to arbitrate this dispute, and I've already mentioned that. But the point is that in the Bombesti itself, we have a very good example of how an award, the interposition of an award or a judgment, can create a marked difference to the legal analysis of a reference to arbitration of a dispute. And what Mr. Justice Aikins held was, because the claim to arrest the vessel was in support of sums which had been awarded in Romanian arbitration, even though the arbitration arose under an arbitration agreement that was in a charter party, which was a contract for the use of a ship, nonetheless, the claim in the Admiralty claim related to the award, not to the contract for the ship, the use of the ship. And that interposition point is central to the reasoning of Mr. Justice Butcher as well in distinguishing the award and judgments claims in terms of the imposition. But and my learned friend says, well, there's no logic in what Mr. Justice Butcher said with regard to the judgment claims. The trouble is that there is a considerable logic in Mr. Justice Butcher's point about the judgment claims. The logic falls down when he distinguished the award claims, which were still interposed. And you have to ask yourself, to what was the relevant relation? And in my respectful submission, this is where Svenska and NML, whilst I would accept formally obiter dicta, but about as persuasive obiter dicta as it is possible to get, you are obliged, I would respectfully suggest, to take a very constrained view of the nation of relation. I mean, we can all say everything relates to something else. In the Bombesti, you could say, well, yeah, the claim to arrest related to a contract of a charter party. But that form of imprecise relation is unacceptable in the construction of this act, and particularly, as I pointed out, in relation to the application of an exception, which is what it is, that the relation is destroyed when one has the interposition of an award or a judgment, as my learned friend's claims under those two actions are necessarily founded. And my learned friend, I think he took objection to my raising the point that what has happened in the present case, where Mr. Justice Butcher accepted the contention of the club that there was a commercial transaction in the form of the judgment. He's formally, I think, objected to my running the argument that whatever happened in Spain is not within the four words of in the brackets of the State Immunity Act, nor therefore of a similar character. And one can, if I can just put it this way, the four words, industrial, commercial, industrial, commercial, financial, and what the other one was?
Judicial.
Yes, thank you. No, not judicial. Professional. Yes. One can understand entirely why those words were there, because they are all words which describe an activity in which a state may engage, which can generate obligations of the state. So there may be contractual obligations, there may be delictual obligations arising out of the operation of an industry. And that's the reason why activity has been put in. But it's when one looks at a judicial utterance, it doesn't create any form of obligation which can then be the subject of an action which is then avoids immunity. Judicial does not generate any obligation on the part of the state. And that's why I say judicial is not of a similar character to the other four. And whether you apply AS dem generis or not, in my respectful submission, you cannot say that there is what has happened here is of a similar character. And if one looks back at the four examples, I mean, the principal reason for the exception is because states entered into contracts which engaged obligations of the state. And those obligations should not be subject to immunity. That's perfectly sensible.
You're here today representing the state. You're not acting in a judicial capacity.
And I'm not acting in a commercial capacity either. I might be acting as a professional. But that's my profession, not the state's.
Well, how are you acting in a judicial capacity?
I'm asking you to produce a judgment. When you produce it, you will produce a judgment which is not the subject of any obligation which is actionable.
Guess what? Mainly our judgment will be a judicial act. Your appearance here, or the appearance of those representing the state in Spain, was not in no sense a judicial act.
No, I'm... But does it generate... If I can just ask you to look at the section 3.3c. And it starts with...
It must depend upon the nature of the claim that's being advanced in court, not the fact that it's being advanced.
Well, I suggest what you need to do is, when you see the four examples, you are seeing examples of activities which can, in themselves, generate actionable obligations on the part of a state. Delict, contract, it matters not. That's activity. But what you cannot do is to say that making a claim before a tribunal or a court is any of those things. It doesn't generate obligation. What it may do is generate an allegation of breach, but it doesn't generate an obligation.
So if a state brings a claim to enforce a commercial guarantee, that's not commercial activity, you say?
Oh, yeah.
Because it's the claim brought in.
Well, hold on. You just said, if you'll forgive me, you said if the state brings a claim to enforce a guarantee, the normal way around is the other way around.
The claim is brought against the state.
Yes.
To enforce a guarantee. That's judicial activity.
No, because it relates to the guarantee, the obligation. Look at the source of the obligation. What obligation has been created by the guarantee? It's been created by the guarantee. If it's in delict, it may arise out of an industrial practice. It's an obligation of the state which arises, but it doesn't arise. There's no obligation of the state which arises from what has happened before in an application before the court. This is where the confusion lies. In my learned friend's case, he says, well, if the particulars of breach can be adequately related, then that's good enough. I say no, the source of the obligation has to be what's critical, not the particulars of breach. And that's why the four examples plus the similar character do not embrace what has happened in Spain. It's just not creative of an obligation. All the other functions are creative of obligations. And one can understand why. As soon as a state undertakes an obligation which falls within those four heads, or something of a similar character, then that obligation is enforceable without a recourse to immunity. But where it is engaging in something which does not generate an obligation, but merely provides particulars of a claim for breach, that does not have the sufficient character and therefore does not have the sufficient relation, and is certainly not a commercial transaction in any colourable way. That's my argument. Right or wrong? But it's on a construction of the Act. It's a question of pure law. My learned friend has indicated...
Well, it's a new argument. It is that subsection C only relates to activities in which claims are made against a state,
Yeah.
not to activity in which claims are made by a state. That's
Absolutely. Well, as soon as the claim is by the state, then there's no immunity, is there? Absolutely right. But my lord, for the moment, all I'm saying is that the point is there. I've raised it. My learned friend says it's a new point. Well, up to a point, I suppose it is. But it's a point of the purest law, and he hasn't indicated any prejudice, and I'm going to urge your
for
lord.
myself, I regard it as a new point you're now making. The subsection C only applies to activity in which a state is being subjected to a liability, rather than activity in which a state makes a claim.
I'm making that point just to identify what is embraced by other similar character. That's all. But I've made the point. I would urge your lordships to decide it. It's a question of pure law. My learned friend has suffered no prejudice. If I'm right, then I'm right. If I'm wrong, then I'm wrong. But I would urge you...
that if you bring the claim here, you don't have immunity. If you bring it in Spain, you do.
Hang on, if you'll forgive me that. If I bring the claim here, I don't have immunity because of Section 2.
Yes. But if you bring it in Spain, you say you have immunity.
But where do I have immunity then? Where? Spain? Or if I bring it in Spain, I don't have immunity in Spain.
You have it here.
Well,
that's your whole point.
Yes, but that depends upon what's happening here. I mean, I'm afraid, my lord, with the deepest respect, that you've got constantly to have in mind where is the immunity being invoked.
But why? Because at the moment, the only point we're on is whether what we're talking about is commercial activity or
commercial transaction.
Or comes within the definition of subsection C. It doesn't matter where it takes place.
No, I agree that is correct. Yes, but where the invocation of immunity is being debated and the application of an exception is being considered, then you have to ask yourself, what is the position with regard to immunity then? And all I'm saying is that when you're looking at the words or similar character, what has happened in this case is not of a similar character. But it's a question of pure law. And I would urge you, if I'm wrong, then I will hold my hands up and say I'm wrong. And Mr. Justice, interestingly, Mr. Justice Butcher said it was the contention of the club that. He didn't say, Spain or the States bent over backwards and said, yes, that's obviously right. I didn't. So I'm just going to say, please decide it. If I'm right, I'm right. If I'm right, it's great, because for Section 3 purposes, it doesn't apply. And if I'm wrong, fine, I'm wrong. But there's every reason now for you actually to decide it and say, well, Young is right or Young is wrong. My lord, the Human Rights Act point, we're at least on point 4, and we're on the last page. Ben Carbuche, it is an irony, perhaps, that the club says Ben Carbuche is binding on your lordships on the true construction of Section 3, even though it never considered Section 3. But Lamp and Wolf, which did consider Section 3 specifically, is not binding upon your lordships. So there are two Supreme Court House of Lords judgments, one which doesn't concern Section 3, which binds you on Section 3, and one which does concern Section 3, does not bind you on Section 3. In my respectful submission, that is nonsense. But when one looks at...
Was Ben Carbush not an application of Section 3?
Yes, but no, it isn't at all. It's an application in relation to the contracts of employment. It never you will never find Section 3 mentioned once in Ben Carbush. Never. You will never find it mentioned in any of the judgment or the argument. It just wasn't concerned. It was about employment. And Svenska wasn't even referred to. Anyway.
I'm so sorry, I'm talking about Section 3 of the Human Rights Act.
No, Section 6.
No, Section 3.
Article Section 3.
Section 3 of the Human Rights Act.
I'm sorry.
I'd misunderstood.
Sorry, I'm talking about Section 3 of the State Immunity.
I'm sorry.
Sorry. That
was my misunderstanding.
No, it's a question of imprecision once again.
It's all about Section 3 of the Human Rights Act.
Yes, I would agree with that. But Section 3 of the State Immunity Act.
Right.
Sorry, which is the one I'm concerned with.
So,
there's an issue about the burden of proof, and I say, well, the simple application of the normal rules about an exception having to be proven is the one, and I think that was the point made by my Lord Justice Males. But the whole point is entirely academic, because it is plain that immunity in respect of commercial transactions is actually, as a matter of customary international law, fairly confined. And if I may just give your lordships some references, I was going to take you to them, but I'm conscious of time's winged chariot. There was in tab 15 of Bundle A1, you will find the fourth report on jurisdictional immunities by the Special Rapporteur, which was submitted to the UN committee that was drafting the articles which ended up as the UN CSI. And the reporter at bundle, it's tab 15, sets out at page 211, which is at the top of the page, what the current practice is. As it were, customary international law, having considered a large number of states. And at 212, he concludes at paragraph 51, it will be seen that while the proposition that trading constitutes an exception to state immunity has encountered relatively little opposition, the actual application of that proposition has not been without doubts and hesitations. The same set of facts could be construed differently by different courts at different levels, surprisingly divergent views. The same activity could be viewed as trading not entitled to state immunity and as non-commercial and therefore covered by state immunity. But then he goes on to submit his report, and if I can take you straight on to the draft articles, which are at tab 15A. And the commentary by the International Law Commission. What we have is at, well, it's page 33 at the top right. We have the conclusion that the exception is commonly referable, is adequately set out in Article 10 of what becomes UN CSI. And it is apparent that the UN, the International Law Commission, accepted the view of the rapporteur as descriptive of international, customary international law. If you go to page 36 at the top left, under the paragraph B, commercial transactions in the context of state immunity, in order to appreciate the magnitude and complexity of the problem involved in the consideration and determination of the precise limits of jurisdictional immunities in this respect, in this specified area of commercial transactions, it is useful to provide here, in a condensed form, a chronological survey of state practice, a survey of judicial practice, international and national, this brief survey, of which a more detailed version has been submitted to the Commission, and then there's a footnote, and then there's a reference to the fourth report of the Special Rapporteur. And we have, at page 40, paragraph 24, there is an analysis or a summary of what is within international customary international law. But one thing is clear, is that what was relevant in the present case is not within what was considered. And therefore, customary international law would have permitted what was the exclusion narrowly construed in Section 3 of the State Immunity Act. Therefore, to construe related in the narrow way that it has been is entirely consistent with customary international practice and law. And therefore, given that Lord Sumption accepted that proportionality could be achieved by a consideration of whether what was being done was consistent with customary international law, the answer is it was. And it is when one has a narrow view of related and there is no offence. Therefore, proportionality is not a problem. Therefore, it doesn't matter. The second point on Human Rights Act is this, in a sense, I've already touched upon it, that it is an irony that by being bound by an arbitration agreement, we are necessarily being deprived of a right to a fair trial, fair public trial. Now, in 99.9 cases out of 100, there's no problem because there is consent, there is a submission. Here, you have to imply the consent of Spain, and that's when the Aramis comes to play, because the Human Rights Act does not permit you to infer consent to an arbitration without doing so clearly and unequivocally. And certainly that would be consistent with the Aramis. And if there is no consent clearly and unequivocally to arbitrate the club's present claims, then the Human Rights Act would prevent the arbitration of that dispute. It's as simple as that. The last point, counterclaims, and I'll be really quick here. It's an English statute. It uses a term that is familiar to English lawyers. One can understand that the normal incidents of litigation are engaged. The normal incident of an regulation enforcement application is not a normal incident. And my learned friend referred to Metro. The critical thing in Metro was that the parties had engaged in an awful lot of litigation. And I won't show it to you now, but if you look at paragraph 10 of the judgment of Lord Justice Ricks, you'll see just exactly how the people who were saying that they were not bound had engaged very positively in litigation. And it was all managed litigation in relation to a number of actions. And the question was whether there could be, under those circumstances, a relevant injunction with regard to American proceedings. So one is talking about a completely different creature. And my last point is that, and it really is the last point in that connection, my learned friend referred to Jarmen, the Jarmen case. Can I just ask you to take it up? It's in C4. Yes, possibly, but I'm just going to show you, Miss Dilnot is understandably champing at the bit. Can I just, my learned friend identified correctly what the case was about, and particularly when it got up to the Court of Final Appeals. But that was a case where there was an attempt to enforce an award. There was a summary enforcement of the award, and then there was an attempt to enforce the award at common law. And what the court below held was in relation to the claim to enforce at common law, it could not consist of a it could not coexist with the existing judgment. And hold on, I'm sorry, I'm looking at the wrong, not this one. Perhaps it arises at a later stage. I've got the wrong reference. The court says the claim to enforce at common law, enforce the award at common law, cannot coexist with the summary judgment. The summary judgment was set aside because there was no informed election. And thus, once you get rid of the summary judgment, then you can proceed to enforce at common law. Now, the point here is that, very far from it, my learned friend has not abandoned his Section 66 judgment. And if you apply the reasoning of the Court of Appeal in Jarmen, a claim to enforce at common law cannot coexist with the judgment. In that case, in Jarmen, they could get rid of the judgment because it caused no problem, and then they could enforce at common law. In our case, that's the one thing that the club cannot and will not do, get rid of their Section 66 judgment, because as soon as they do, it will completely answer the application to enforce.
My fault, I hadn't seen where in Jarmen the statutory judgment had been got rid of, as you put it.
It's because the court says they cannot coexist. And I'm afraid, my lord, I think the flag that I had has gone. Perhaps I can show it to you in...
Can I help, my lord?
Almost certainly not.
And the young things I almost certainly can't say.
All right, well, we'll ignore those.
No, I'm sorry. No, I'm sorry. That was...
If I can try and help, at least, my lord, the position in the Jarmen case was that the summary enforcement order was for specific performance, specific performance in the technical sense, because you couldn't get specific performance as a matter of law of the type of contract in question. So there was an order that the parties continue performing the contract. The Court of Appeal concluded that an action for damages failing to perform was inconsistent with an order for continued performance of the contract. And so because of that inconsistency, then it wasn't possible, given the terms of the two orders in question, to have both an order to continue performing and an order which was dependent upon the hypothesis that performance hadn't been continued. those circumstances, then the Court of Appeal said that we'll have to choose between the two. And what happened was then that the claimant chose to go ahead with the damages on the award, rather than keeping the judgment requiring continued performance of the contract. The question therefore arises as to whether the judgments in this case are mutually inconsistent, and that will, when we get to it, my submission will be that's a question on the merits, nothing to do with immunity at all. It's a question on the merits which will have to be considered at the trial of the matter. And as your lordships know, my overall submission is that your lordship shouldn't be concerned with the merits on a jurisdictional challenge of the issues, but just actually so that your lordships know how the issue arose in the Xiaomen case.
And did what you've just described happen? I think you said Court of Appeal, so that's as distinct from Court of Final Appeal.
Court of Final, by the time we got to the Court of Final Appeal, the election had been made.
So we find all that in the lower judgment.
And you find all of that, therefore, in the Court of Appeal judgment, not in the Court of Final Appeal.
Which I don't. Do we have in our bundle?
Yes, you have.
It's tab 35.
35. Can I?
That answers your lordship's
Yes.
So if
I think it does.
It's actually described in the judgment of the Court of Final Appeal at paragraph 64 to 70.
Is it?
All
right.
It describes what
yes.
has happened.
Everybody's helping. Can I apologise for what may have seemed like a briefly intemperate remark? It was more.
All right. Well, don't worry.
If I'd been wearing a mask, you wouldn't have heard it. And I apologise unequivocally to my learned friend and to the court.
unnecessary.
Well, that's
All right.
very decent of you. Can I just say, it's paras 193 and 194 of the judgment, which is at tab 35 of bundle C3, where the learned judge says, in my view, the judgment entered under the statutory process cannot coexist with a judgment for the damages which the plaintiff is seeking in these proceedings.
All right. Well, it sounds as if we haven't heard the last of them.
I don't think you have,
Where you,
but the fact that my learned friend referred to Xiaomen, I felt that I probably had to refer to it now. My lords, I'm conscious that I've gone on far too long, but it is an important case. There are many important issues, and there's a lot of money at stake, as well as a lot of rather important
yes.
state
All right. Well,
issues.
thank you.
I apologise. Unless I can assist you, I was going to say assist you further, but that's probably...
Yes. All right. Well, Mr. Hancock's already made that.
Thank you. Right. Thank you.
Yes. Now, I think it's Mr. Hancock next, is it, on jurisdiction?
It is, my lord. Lords, I'm going to deal firstly with the award claims in relation to the jurisdiction issues before turning to the judgment claim, and then I'm going to end up with the Section 18 application. And in relation to the award claims, then, as the lordships know, then the first question, perhaps the major question, is which the appropriate regime is in accordance with which jurisdiction falls to be determined. And there are two possibilities under this head. The first is that the common law regime applies, i.e. CPR 6, and the second is that the Brussels regulation applies. And which of the two regimes is applicable depends in essence on whether the claims fall within the arbitration exception in Brussels Recast. Secondly, depending upon what the answer is to the first issue, then if the common law test is the applicable test, does the English court have jurisdiction? And under that heading, it is accepted that two of the three tests are satisfied. The only test is whether the award claims have a real prospect of success. Secondly, if the Brussels regulation applies, then the question would be whether, under that regulation, the English court has jurisdiction. Since the issues under the second limb, i.e. the Brussels regulation issues, are essentially the same issues as arise in relation to the judgment claims, which is the heading under which the judge dealt with them, because in front of the judge it was common ground that the award claims did fall within the arbitration exception in Brussels recast regulation. I'm proposing to deal with the Brussels regulation points other than the arbitration exception in the context of the judgment claims rather than in the context of the award claims. So if I start with the question of the application of the arbitration exception to the award claims, then the recast regulation is at bundle B1 of the authorities bundle at 2. Your Lordships will be very familiar with the terms of this regulation. Indeed, some of your Lordships probably wake up in a cold sweat actually thinking about it, but the relevant sections of the regulation, we can begin with the recitals in the regulation, and in particular recital 12, which is the recital that deals with arbitration. Perhaps if I can just ask you, Lordship, to remind yourselves of the wording of that recital. So, your Lordships will see that there are a number of different, if you like, limbs to the recital. The first is a simple statement that the regulation should not apply to arbitration, and therefore nothing in the regulation should prevent the courts of a member state from referring the parties to arbitration when there is an arbitration agreement. Secondly, then the recital deals with rulings of courts as to whether or not arbitration agreements are null and void, inoperative, or incapable of being performed. And those are not enforceable pursuant to the rules in the regulation. Thirdly, then the recital goes on to state that where a court of a member of state has determined that an arbitration agreement is null and void, that should not preclude the court's judgment on the substance of the matter from being recognised in accordance with the regulation. But this is to be without prejudice to the provisions of the New York Convention, and the New York Convention is to take precedence over the regulation. And fourthly, and perhaps most importantly for present purposes, then the regulation is not to apply to any action or ancillary proceedings relating to, in particular, the establishment of an arbitration tribunal, the powers of arbitrators, the conduct of an arbitration procedure, or any other aspects of such a procedure, nor to any action or judgment concerning the annulment, review, appeal, recognition, or enforcement of an arbitral award. I emphasise in that context the words enforcement of an arbitral award. Then, going on to the text of the arbitration, of the arbitration exception, in Article 1 of the regulation, heading of scope and definitions. And then the very simple provision that the regulations shall not apply to arbitration. That's 1D.
2D.
Yes. On 1-2D, Phillips is quite right. So those are the relevant provisions of the regulation. And as your lordships will also be aware, that those provisions were the subject matter of consideration by the draftsmen of the reports that were produced at the time of the original Brussels Convention. That was the report produced by Professor Génard, and by the draftsman of the report, namely Professor Schlosser, who drafted the report which was prepared at the time of the accession of the UK to the Convention in 1978. And those reports are regarded as of special significance as travaux preparatoires in relation to the interpretation of the Convention. And both of them deal with the subject matter of arbitration. We have both of them in the bundles, and we'll confine those in bundle B2. Beg your pardon, my notes are wrong. It's B1, it's tabs 3 and 4. If we start with Professor Génard's report, that deals with this relevant subject matter at page 13. In a short paragraph, perhaps again, if I just ask your lordships to read that paragraph under the heading D, arbitration.
Yes.
And then the Schlosser report is tab 4, and the relevant sections of the Schlosser report are paragraphs 64 and 65. Again, if your lordships go to those paragraphs, that probably I can ask your lordships to read from 63 to 65. So, in particular, paragraph 65C, you will see makes clear that court decisions incorporating arbitration awards, i.e. section 66 are not within the regulation. But that is a subset of the statement that the Convention does not cover proceedings and decisions concerning inter alia recognition of arbitration awards. So the United Kingdom procedure via section 66 is recognised as being one such method. But equally, I would submit the action on the award is an action to enforce an arbitration award, which could therefore come within the general description in paragraph 65C as being one of the types of proceedings If we then move to the European authorities dealing with the question, then I would submit that the position becomes clearer still. And we can start with the decision of the CJEU in the Atlantic Emperor, which is in bundle 2, I think, at tab 18. Your Lordships will probably recall this was a decision made on a reference from the Court of Appeal in this country. And the question that arose was whether an application to appoint an arbitrator fell within the convention or not, in circumstances in which there was a dispute as to whether or not there was a binding arbitration agreement. So you'll see from the headline note, just reading each of those paragraphs, firstly, that by excluding arbitration from the scope of the EEC Judgments Convention on the grounds that it was already covered by other international conventions, the contracting parties intended to exclude arbitration in its entirety, including proceedings brought before national courts. Secondly, it said the appointment of an arbitrator by a national court is a measure adopted by the state as part of the process for setting arbitration proceedings in motion. Such a measure therefore comes within the sphere of arbitration and is thus covered by the exclusion contained in Article 1.4 of the Judgments Convention. And thirdly, they said in order to determine whether a dispute falls within the scope of the regulation, reference must be made solely to the subject matter of the dispute. If by virtue of its subject matter, in casu the appointment of an arbitrator, a dispute falls outside the scope of the convention, the existence of a preliminary issue which the court must resolve in order to determine the dispute, whatever that dispute may be, in casu the validity of an arbitration clause in the contract, cannot justify application of the convention. And then over the page, reiteration really of the same point, the fact that a preliminary issue before a national court relates to the existence or validity of an arbitration agreement does not affect the exclusion from the scope of the convention of a dispute concerning the appointment of an arbitrator. Then if we go to page 543 of the report, in the opinion of the Advocate General Darman.
I'm so sorry, which page?
543. And the Advocate General there says that legal writers agree that the Convention does not apply to disputes related to arbitration. The only disputed point concerns the difficulty with which I have already dealt concerning the recognition and enforcement under the Brussels Convention of a judgment which disposes of the substance of the dispute despite the existence of an arbitration agreement. But even in the view of those authors who favour application of the Convention in such cases, all disputes concerning arbitration fall outside the scope of the Convention. And then actually in the judgment of the report itself, we go to paragraphs 18 to 22 of the judgment, and that is begins at page 559. So if I can ask your Lordships to read those paragraphs 18 to 22. Up to 29. So your lordships will see that the court emphasised the breadth of the exclusion of arbitration from the regulation. Hence the use of the phrase the contracting part is intended to exclude arbitration in its entirety. So although on occasions then reference is sometimes made to the fact that the justification for excluding arbitration is said in the reports to be the existence of, for example, the New York Convention in relation to recognition and enforcement, and as your lordships have seen, the potential existence at the time of the original convention of a European convention on the same topic, then the exclusion that was in fact settled upon was much broader than that and extended to all proceedings relating to arbitration, not just recognition or enforcement, but also supervisory proceedings, appointments of arbitrators, curial law proceedings, all of those outside the scope of regulation. For present purposes, however, I emphasise again that what we're here concerned with is an action enforcing an arbitration award. And it is clear, I would submit, from the reports at the time of the convention and from the breadth of the exclusion here, that such actions are intended to be excluded from the Brussels regulation.
What you're doing is claiming damages for breach of an obligation which was declared in an award.
Yes.
Is that the same thing as enforcing an award?
Well, the action on the award, which I referred to in the Annals of Reefer, is an action to enforce the award. What I will show you, lordships, in a moment is the rationale for the exclusion of arbitration expressed by the European Court, by the House of Lords, and endorsed by the European Court in the Front Comore. And the rationale was that insofar as the relevant action is intended to vindicate the right to arbitrate and uphold the right to arbitrate, it is out with the scope of the regulation. And my submission is that here, quite clearly, the intention of the award claims, and in due course I will be submitting the judgment claims, is to uphold the right of the part of the club to have the disputes arbitrated and the relative obligation on the part of the states to arbitrate its claims. And therefore, the purpose of the proceedings is actually to uphold and enforce and vindicate the right to arbitration. That is a purpose which the European cases say is outside the scope of the regulation. It's left to national laws and the national laws governing the arbitration agreements in question, rather than being the subject matter of the regulation, which is, after all, a regulation which has to do with the allocation of jurisdiction between the contracting states of the European Union, rather than allocation of jurisdiction in relation to arbitration, which of course is a matter which goes well beyond the states of the European Union.
But the claim isn't to uphold the right, it's to claim damages for the fact that the right hasn't been upheld.
Well, the claim is to uphold the right, because although the claim is to claim damages for breach, then it is to vindicate the right in the sense that the compensation is because the right has not been respected. And therefore, actually, in that sense, the position is that one is seeking to uphold the club's right to have disputes arbitrated. The remedy that the club now seeks in respect of that is actually a remedy compensating it for the fact that its rights have been infringed. And again, it's perhaps intriguing that it was never suggested in relation to the first set of claims of those were within the scope of the Brussels Convention or regulation. And those were just as much as it were to, because of the fact that they were arbitration claims, not actually claims which fell within the titles within the regulation. And I'll show you, Lordship, in relation to a later issue that arises in relation to the regulation, that the regulation is said to be, has been said to be title based. So you look at the particular type of action that is being brought. And if you ask, well, what is the type of action that is being brought in this instance, the answer is it's an arbitration action. It's an action for breach of an obligation to arbitrate. And if you ask, well, is that something which the draftsman of the Brussels regulation intended should be governed by the Brussels regulation? The answer is quite clearly from these materials, no, because the intention was to ensure that arbitration was left completely outside the scope of the regulation.
So as you say then that whether the claims turn out to be good or bad claims is, as it were, a merits point, but the claims are within the sphere of arbitration and their subject matter is whether the effect of the arbitration and the awards is to give rise to the liability which you're claiming exists, and that's an arbitration matter.
Well,
that's essentially how you put this point, is it?
Absolutely.
Yep. Okay.
And I can then take your Lordship's encapsulated my point entirely, and the other authorities that we've referred to, your Lordship will probably be familiar with them anyway. We have the Van Uden case. That was a case in which the European Court held that the mere fact that arbitration proceedings were involved. Well, let me take you to the case. It's at tab 21 in this same bundle.
That was provisional remedies.
It was provisional remedies, and the question was whether or not, in the context of an arbitration, where the court was being asked to grant provisional remedies, then that matter fell within the arbitration exception. And the court said, no, it didn't fall within the arbitration exception, because what was being sought was provisional remedies. And the fact that there was an arbitration, if you like, in the background was irrelevant to the question. So the relevant passages are at paragraphs 26 to 34 of the judgment. And the court made the point, firstly, that where there was an arbitration agreement, then the only relevant provision of the regulation was Article 24. That's paragraph 25 of the judgment. And then they went on to consider a submission which had been made by the defendant and the German and UK governments, that where there was an arbitration agreement, interim proceedings also fell outside the scope of the convention. Perhaps if I can ask your Lordships to read to the end of paragraph 34, you'll see that that contention was rejected, and you'll see why it was rejected. paragraph 33, therefore, your lordship will see that what is said is that the relevant question is what is the nature of the rights which the relevant articles serve to protect, and we would submit that the nature of the rights that are sought to be protected in our case are the rights to arbitrate, as I've already indicated, and that therefore, looking at that test that way under the regulation, then the regulation would say that given that the nature of the rights that it is sought to protect are arbitration rights, given that arbitration is out with the scope of the regulation, therefore these proceedings which serve to protect those rights are also out with the scope of the regulation. And if we can go briefly to the front comal, which is at tab 25. The judgment in the case begins at page 1153 of the report. Your lordships are all familiar with the facts of the case. Lord Justice Mayles appeared in the case, and therefore will be very familiar with the facts of the case. This was a reference from the House of Lords, and the House of Lords had indicated in its view the relevant matter was out with the scope of regulation. But at paragraph 15, the views of the House of Lords are set out in the judgment of the European Court of Justice. The question in this case, as your lordships all I'm sure remember, was whether or not an anti-suit injunction could be granted in the courts of a member state in support of an arbitration agreement. The European Court of Justice held that it couldn't because it would contradict the principle of mutual trust. But for my purposes, if we go to paragraph 15, then that records the House of Lords views that it's clear from the judgment in Mark Rich that the exclusion in 1.2d of Regulation 44 applies not only to arbitration proceedings as such, but also to legal proceedings, the subject matter of which is arbitration. The judgment in Van Uden stated that arbitration is the subject matter of proceedings where they serve to protect the right to determine a dispute by arbitration, which is the case in the main proceedings. That was the way in which it was put by the House of Lords.
Well, I think the point was that the House of Lords thought that the English proceedings for the anti-suit injunction fell within the arbitration exception, and the House of Lords thought that that was the decisive consideration,
yes.
Whereas the Court of Justice in Luxembourg thought that was not a decisive or even relevant consideration. The question was whether the proceedings in Italy fell within the regulation and whether the claim for an anti-suit injunction interfered with those proceedings.
Quite so, my point was simply that when the European Court of Justice considered what the House of Lords had said in relation to the nature of the English proceedings, which is at paragraphs 21 to 23, it endorsed the House of Lords' views, namely that if the English proceedings were in support of the right to arbitrate, within the arbitration exception. But your Lordship is quite right that the European Court of Justice went on to say, however, they were nevertheless, the anti-suit proceedings were nevertheless an interference with the Italian proceedings, which was a wrongful interference because it ran contrary to the principles of mutual trust.
Yes.
It's what I seek to drive from the Franco law is the principle that it's the nature of the proceedings and the rights that the proceedings seek to vindicate, which is the important question in determining whether they come within the arbitration exception. And before your Lordship, that's the question, whether they come within the arbitration exception. And then lastly, my Lord, although these cases came before the Franco law in particular, then perhaps I can just refer your Lordship to the relevant cases and the passages in the cases rather than taking through what are relatively lengthy passages. Then the English and the European cases were reviewed by Mr. Justice Akins, who then was in the Ivan Zagabansky, in a very long review, which is 40 paragraphs long. That is at tab 9 of bundle B1. And perhaps if I just take you to one paragraph of it.
By all means, but is there anything in there which is important, which we don't get from the House of Lords and the European Court in West Tankers?
I don't think so, my Lord, no. Not my case. The only other point I was going to make is that review of the authorities by Mr. Justice Akins was endorsed by the Court of Appeal through Transport number 1. And you'll find that at tab 43 in bundle A4. The relevant paragraphs of bundles 38 to 48, and in particular paragraph 47. So, in relation therefore to the specific question as to whether an action on the award or an action of damages for failure to adhere to the award is within the arbitration exception, then I make a number of submissions, and these reflect points, just so that the Lordships have these in mind, which we make in paragraphs 181 to 183 of our skeleton. The first is that an action for damages to honour, damages for failure to honour an arbitration award is akin to a claim for breach of the arbitration agreement itself. In one sense, then, adopting my Lord Justice Popplewell's analysis as put to me yesterday, and then the original obligation is the obligation to arbitrate. Then where, as I put it yesterday, that obligation is restated, that's to say that there is an arbitration award which declares that there is an obligation to arbitrate, then the obligation, the award states that there is an obligation which must be complied with, and if the obligation which must be complied with is an obligation which falls within the arbitration exception, then an obligation to honour the award which itself must also be an arbitration within Article 1(2)(d). Of course, there is a separate question, going to the point that Mr. Young has made on a number of occasions, as to whether or not an action or a declaration, if you like, adds anything to the original right. But that's a question of the merits of the underlying claim, not a question which goes to the nature of the claim, which is the relevant question for the purposes of the Brussels regulation, just as it was in relation to the state immunity argument. And I will come back to the merits of the claim to the extent necessary to do so in due course. For present purposes, particularly given the interest of time, I want to concentrate on the jurisdiction issues that arise. The second related point is that the action on the award is a claim on the award of common law, the Anderson Brief Report. And again, I would submit it's clear from the Schlosser report and from recital 12 of the Brussels Recast that actions for the enforcement of awards are within the exception to the regulation. The club action is no less an action on the award as in an action on enforcement of the award, because it is not simply a section 66 action for a repetition of what the award says. Because unlike the summary procedure in section 66 subsection 2 of the Arbitration Act, actions on the award are not confined to relief in the terms of the award. And we see that from a number of cases, including the Hong Kong case, to which I will take you in due course. It also appears from the Dalmia Dairies case. It appears from a case called Berkeley. It also appears from a case called Windy Look. And the point there is that the statute places a restriction on the remedy that the court can give. The statute specifically states that all the court can do is to restate what is in the award. You recall that Mr. Young showed you, I think it was the Sonatrach case, in which the two judgments of Mr. Justice Aikens were cited. And there actually the issue was whether or not interest could be awarded going beyond the interest that had been awarded in the award itself. And the answer was no, it couldn't. The further question that then arose was, once you had actually turned the award into a judgment, could you then award Judgments Act interest on the judgment thus rendered? To which the answer was yes, you could. But it doesn't follow from any of those propositions that where you have an action on the award itself, that the remedies are limited to the remedy granted in the award.
Right. I think that's your second proposition. Is that a convenient moment, Mr. Hancock?
It is.
Very well. 2 o'clock.
All right.
No, I was just, I did not